Parsons, and I'm going to address some frequently asked questions I get about my paralegal business. And more generally, questions that potential clients have about their legal issues. Firstly, I'd like to address a common one, and the question itself is, can I sue? The answer to can I sue is always yes. That means that it's probably the wrong question. The answer is not can I sue, it's can I win? Can I get paid? Anybody can sue anybody, but you want to do it only if you're going to be successful. Litigation's a full contact sport. It's not for the faint of heart. There will be some difficulties. You will have to put some effort into your case. Regardless of who you hire and what the case is, there are going to be some trials and tribulations along your path. You got to be ready. So, what then is the right question? Well, there's a couple of things you need to consider for each and every case, or cause of action is the legal term. So, do I have a cause of action, or do I have the right to make a claim that is likely to be legally successful against another person? For example, if you have somebody's given you a check for a repayment of a debt, the check is bounced, then yes, that gives rise to a cause of action. Somebody's assaulted you and caused you damage, so they've broken your arm, you've missed 6 months of work, that sort of thing, that's a tort, and torts can give cause of action. So somebody's hurt your property, hurt you, and there's a wide variety of things that can give rise to a claim. Once you've determined that, do I have a cause of action? And that's where legal professionals can, quite frankly, be of great assistance, because what you think is important and what the court will think is legally important are normally two different things. But once you get there, you have a cause of action, the next question to be answered is, can I get paid? There's no point in going through the trial process, if you will, issuing a claim, getting a defense, going through a settlement conference, incurring those legal costs up front, and the trials and tribulations I spoke of, to get a piece of paper that says that you are now entitled to $19,321.18 plus costs and interest. That will not get you a cup of coffee at Tim Hortons. You have to take that judgment and you have to be able to enforce it. And what do I mean by enforce? Well, you can garnish wages, you can garnish bank accounts, you can put writs on property. Those kind of things will get you payment. If the other person's what they call judgment proof starting out, so for example, they're on a fixed income that is of the sort that cannot be attached, and they have no assets, then you can sue, but once you win, it's going to be a very hollow victory. You'll have tossed essentially a lot of good money after bad, and you won't be happy with me, you won't be happy with the courts, or with yourself. So, two most important things. Do I have a cause of action? And you should normally consult a legal professional just to see in the consultation process if there is a legitimate cause of action. And two is, can I get paid? Once you've established that you can get paid, then you need to look at the economics of the situation. Is it worth it? Someone bounced a check for $15 for Girl Guide cookies for your daughter, and it cost you $20 at the bank, then the answer is probably not, economically. If it's $1,500 in home repairs, again, may or may not be economically viable. Part of this conversation is going to be how much you can help yourself. We can do what's called unbundled legal services, where I can help you with either the framing of the argument, so you understand what the cause of action is and you know how to plead it correctly. Or I can go start to finish and act for you all the way through. Obviously, different price ranges. For a fully defended court action with no motions or extraneous extra stuff added in, you might be looking at a $3,000 bill if it goes all the way to trial. Typically, starts with a $500 retainer, and as we go through the steps, that retainer gets refreshed. At each point in time, we have a consultation, is this worth it? But you have to look at the costs that you're going to put out, what can I recover at the end, is this an economically viable position I'm taking? Because if it's not, then you should wonder, why are you taking action? Now, if the amount is considerably over $25,000, then you need to be in a different court and you need a referral to a lawyer, which I would be pleased to help with. If it's between 25 and 35 or even 50,000, in that range, you may want to consider small claims depending on the cost of the action and the ease of recovery anticipated. And of course, $25,000 and down, you are in small claims court. That depends, again, always exceptions in the legal world, depends on what you need the court to do. Small claims court can order somebody to return your property. So you can say, yes, give the man back his car. It can say, pay the man $20,000, $25,000 plus costs and interest. What it can't do is say, the man, say for example, you were looking at an older vehicle, classic. You were going to purchase this classic, you thought you had a contract for it for $15,000, looked like a done deal, everything looks good, and you've rented a garage, you're prepared to restore this vehicle from the ground up, you've bought a pile of tools and all the materials, you're ready to go, but the person backs out of the sale of the vehicle. Now, they don't have a good reason for doing so. They've merely said, look, I'm not going to finish this, here's your money back, or whatever. You don't want your money back, you've incurred all this cost, now you've hired people to restore this vehicle, etc., etc., so you want the vehicle. It's not like it's a classic vehicle, there's not a lot of them lying around, you can't go get another one. You want that specific vehicle, because that's the one you bought and bargained for. Small claims court cannot order what they call legally specific performance. They can't order that vehicle to be sold to you. So you see it all the time in properties where sales are not quite completed or for whatever reason. There can be, that's not all the time, but there are times when you do need specific performance. For that you need superior court. It can't be done in small claims court.